So you guys are the only two media personnel, correct? Okay, I just know he, I told him he can split screen it and still share screen with in order to show.
Oh, okay, yeah.
And I'm gonna probably most likely be in here anyway to help with.
How you doing? Good. All right.
Hi, Mr. Sims.
How you doing?
Good, how are you?
Is Johnston here?
Yes, he was in the, back where the prosecutors normally sit.
Okay. All right. Let's see what's happening.
I don't know if they're gonna use it for you. This is for now. It's,
tú que me dijiste.
Just old-fashioned high school. So it's like how it all happened. So you got back there to the spot and then you sat. Just old-fashioned.
Good morning, how are you?
How are you?
Good. I was confused, you or maybe you are Sal? Okay, Sal, I confused you, but I'm missing.
S-A-L-E-H.
Oh, it is, okay, thank you so much. Yep.
How long have you been here, Missy?
15 years. Yep.
I don't think we, they've had me locked up in the office for about 15 years, so we probably haven't seen it.
What's that?
Have we worked together before?
Back before you were, when you were just like a floor boss.
Yeah.
Yeah.
We have, there's a big gap of time, times went by, like,
Yeah.
still, I don't know who's up here.
Right.
Well, somebody's gonna say, themselves. We have Wednesday's gonna take us to 5. Where do we feel about that? Any job? Now, how do we, the Zoom's up there, right? Yeah, it's started the Zoom, how do I run out of Zoom here? Where's the Zoom right there? Mr. Johnston, can you hear? Can you hear me? Mr. Johnston, can you hear me?
Yes, I can hear now.
Okay, who do we have online? Oh, that's Chris, and is Mr. Johnson there? Looks like he's, logged in, but, so somehow we have to share the screen so we can see what we're doing.
Okay, can I hear me now?
Yes, we can
You guys, oh, okay, there.
So I'm gonna warn you, there's a couple of graphic photos in the slideshow. Not so graphic, but just a couple of photos that might be upsetting. And so I'm gonna share the screen with you. I don't know whether we're gonna be playing this or not, depends on what happens in the courtroom. I wanted to let you know, there's gonna be like a slideshow.
Okay, the last sentence you did, it came in unclear. What did you say?
I said, there's gonna be a slideshow where I'm going to share my screen with you so that you are aware of this, of what's going on in the courtroom.
Okay.
You see on your screen, is this shared?
Yes.
You see where it says State v. Viktor Vendler?
Yes, I
The
do.
one, okay. One of there's a couple slides in here that are graphic in nature in terms of the crime scene itself. Not too bad, I covered some of the parts out, but just so that you know.
Okay, thank you
If
for that.
if you want me to take off and not share the screen, I can do that as well.
No, I want to see it all.
Okay. Okay, so we're gonna be, we still haven't seen, okay, I'm gonna go ahead and mute, and so go ahead and mute yourself, and, next time, I'll come, we'll hopefully be started.
All right.
And so it's, who's there? I know you're his brother. Is there anybody else with you?
No, I just got back in from Portland this morning, so I'm here by myself.
Okay, I just wanna make sure the records,
Yes.
reflects who's with us. All right, thank you, sir.
Okay, thank you.
So I'll mute us and then I'll just mute myself so that's not. Excuse me, hi, Catherine. standing up here at the podium?
I don't know.
And you guys the prosecutors?
I'm the prosecutor.
Okay. So you stand over here and defense over here?
Yeah, usually the defense is over there. I don't know how the judge, is going to control the courtroom in terms of sentencing, whether you want the defendant up here or
Okay.
usually, me, do you know?
I know what's.
Are you law clerk up here, staff attorney here?
I'm just a student.
Oh, external, okay. All right. Sorry. I'm gonna guess that, oh, we got the plane that fast, huh?
Man, got off the plane, went home, and.
So you're gonna be up, you guys are gonna be up next, so.
Okay.
We have to do Victor.
Because then we could get both sides and then.
Listen, I talked to Ruth, to make sure we're all on the same page, there's 2 counts of information. He's pleading guilty.
you're gonna be a witness, you can.
Are you guys just observing? You could actually just switch over there, so it's easier for them to move with me. And you're close. They're just observing, but I want them to get that move with me easily. And everybody has their copies of everything. Anybody need a copy of anything else before I bring the judge out?
We don't have that withdraw copy.
You don't?
These two, these are the same thing. I think she's sending a different, a third.
She would do it on the record. If the court inquires, she's going to draw.
Yeah.
Cause I'm like, I just got these two today. I
Yeah,
don't
no.
have anything else. Okay. And then, as you guys usually know, tap for on, this is to speak when they're, so the Zoom people can really hear you.
Gotcha.
F.B. Beaudry presiding. All persons having business before the court are admonished to draw near, give attention, and you shall be heard. May God save the United States, the state of Ohio, and this honorable court.
Thank you. Please be seated. I have before me request to broadcast televised from WOIO and WKYC. I will now approve. We are here in the case of the state versus Viktor Vendler, case 692-453. Will counsel please identify themselves for the record?
Good afternoon, Your Honor. Salah Hawadallah, Assistant Prosecuting Attorney.
Lieutenant Don Silvas with the Cleveland Metroparks Police Department.
Megan Hunt with the state of Ohio. Alexandria Sordaro on behalf of the state of Ohio.
Craig Smotzer on behalf of Mr. Vendler.
Thank you. Thank you. Mr. Vendler is also present. Thank you, Deputy, for your help. I have before me a handwritten appears to be from apologize to the court for my indecision. Was this your note, sir?
Yes, Your Honor.
Had defense counsel seen it?
We have, Your Honor.
As the state.
Yes, Your Honor.
Thank you. I also have before me a letter mailed on June 20th, undated, I misspoke, it is dated June 24th, and signed by Mr. Vendler. Did you send that as well, sir?
Yes, Your Honor.
Has the defense seen that letter as well?
Yes, Your Honor.
As the state?
Your Honor, we just received both of these letters this morning. Yes.
Thank you. I have not seen them before today myself. Mr. Shaughnessy, would you like to address the content of these letters?
Yes, Your Honor. We have had the opportunity with Mr. Vendler.
You indicated in the letters that you were having difficulty understanding the procedures earlier.
Yes, Your Honor.
Specifically that you were, quote, disassociating heavily that day, so it was difficult to comprehend what was going on, unquote. Were the letters truthful when you wrote them?
Yes, Your Honor.
And why have you now changed your mind?
I've spoken with my attorneys and I got a better understanding of the situation, Your Honor.
No one should enter a plea in any court in this country without fully understanding what's going on and doing so freely, voluntarily, and knowledgeably, that is, knowingly. Looking back, do you believe that you were able to fully understand what you were doing and enter the plea that you meant to enter when
Yes, Your Honor.
that was a very long pause?
No, Your Honor.
Mr. Shaughnessy, anything further on that point?
No, Your Honor.
Mr. Sponsor, anything you wish to add?
No, Your Honor.
Would the state like to be heard on this point?
Yes, Your Honor. So the state's understanding is on June 18th, I believe. So it was here to discuss the competency, second competency report. The first competency report we received on June 3rd opined that Mr. Vendler was competent to stand trial, but there was some issue with, or more time was needed for the DID, dissociative identity disorder issue. And so this court then provided Dr. Swales of Court Psychiatric Clinic more time to address that and to test for that. And so therefore, on June 3rd, we reset that hearing date to June 18th, anticipating that the second report will be received. And I just want to make sure these are part of the record, which is the Court Psychiatric Clinic report dated June 3rd and the one report dated June 17th. And so the second report came through. Bottom line, Dr. Swales indicates that his opinion had not changed, that in his opinion, a reasonable degree of psychological certainty that Mr. Vendler is capable of understanding the nature and objectives of the proceedings against him and is able to assist in his defense. With regards, so that the finding has not changed in terms of competency. With regards to why Dr. Swales was given more time to check out and explore this DID issue, he does administer 3 tests to Mr. Vendler. And on the dissociative symptom scale, Mr. Vendler, he writes, endorsed a high level of dissociative symptoms equals a total of 70. However, balancing that out is what I think the issue is here, is that the total score with regards to the second and third test, which the second test tests for feigning, potential lying, potential, trying to, basically fib. And his total score was significantly elevated, indicating a high likelihood of potential feigning. So the test is that there's a high level of potential feigning, which is a total score of 47. On the SIRS-2 test, also administered, it says Mr. Vendler has a pattern of markedly elevated scores that are strongly characteristic of an individual feigning a mental disorder. This pattern is rarely observed in examinees with genuine disorders who endeavor to present themselves accurate. So he goes on to say that so there's really, it casts doubt on the first test with regards to dissociative symptoms. And there's no issue, and the state's not saying that there isn't some sort of mental underlying issue here with Mr. Vendler, but with regards to how it affects Mr. Vendler and Mr. Vendler's day-to-day activity, there has been no findings. The state has not been able to find an actual diagnosis of DID in history, and not even here with Dr. Swales in his testing. There are other diagnoses. So there are documented diagnoses from military and from other hospitals, but they don't rise to the DID. I believe there's ADHD issues and things like that. So just want the record to reflect that DID was explored with those results that I just. It concerns the state that the wording of the 2 filings, which is that it's not, they wanted to withdraw because they didn't understand back then. And I think the answer to your question was that a truthful statement? And Mr. Vendler indicated it was. So at this time, I do have some witnesses to put on. There have been jail calls monitored to indicate, I think, and to make the record that Mr. Vendler fully understood the plea, fully accepted the plea, looked forward to being sentenced to prison, and only after a conversation.
I don't know that he looked forward to it. He certainly understood that was in the offing.
Yes, understood the sentence, understood that the prison was in the offing, understood the life detail, and understood the 21 years that had to be spent before eligibility before the parole board. It only changed after a discussion with Mr. Vendler's mom, when Mr. Vendler's mom put an idea into Mr. Vendler's head regarding, maybe you didn't understand, maybe this is something that you were rushed into, and so then that's, I think, the genesis of these letters. So we can either two ways is I think another criminal rule 11 inquiry may be best in this case, just to make sure that today, as we sit here, and I know we've done it before, and I know competent counsel is here, and it was very clear on the record, very clear to the state of Ohio that he accepted the plea and entered guilty pleas to the 2 counts, aggravated murder, prior competent design, and the use of corpse. But it's either that or I put on witnesses to substantiate what I said with regard to the jail calls. I have a detective here who's listened to those jail calls and can testify as to her impressions of the jail calls and the idea. So, and I also then, we are going to go through the sentencing. I do have a couple of other exhibits that I want to make sure the record reflects. The record has the information that it needs to reflect that the plea was a knowing and voluntary plea vis-a-vis the evidence that the state has collected with regard to this. So, again, I think either a more full inquiry with regards to Rule 11 or maybe both hearing that can place more information on the record.
Thank you. Would either of the other two assistant prosecuting attorneys like to be heard on this point?
No, Your Honor, thank you. No objection.
Thank you. Mr. Johnston?
Judge, I guess from the defense at this point, we believe that motion was withdrawn. We do not have a request to withdraw the plea, so I think that we are good to go forward with the sentencing today.
Do you think, under the circumstances, it would be a better approach to go through your client's Rule 11 rights again, or do you think it would be unnecessary under the circumstances?
Judge, I believe our position would be that it's unnecessary at this point because we do not have a pending motion with the court.
Do you concur, Mr. Smelser?
Yes, Your Honor.
As I recall, I specifically, in light of the past mental health issues in this case, asked defense counsel if they felt their client, as medical lay people, legal professionals, that their client was fully oriented and able to understand what was going on. Is that so, Mr. Johnson?
Yes, Your Honor.
And my recollection was both you and Mr. Smelser thought your client was fully capable of understanding and was entering a knowing and voluntary plea. Is that so?
That's correct, Your Honor.
Is that your recollection as well, Mr. Smelser?
It is, Your Honor.
I think under circumstances then, although I appreciate the state offering the proposal in abundance of caution, going through the defendant's Rule 11 rights again would be unnecessary. Would you agree, Mr. Vendler?
Yes, Your Honor.
Very well. Would the state then like to be heard as to sentencing?
Yes, Your Honor.
You may proceed.
And the state is going to has four exhibits that it wishes to enter into the record, and these are all exhibits except for the PowerPoint which I'll be playing here, as defense counsel is aware of. PowerPoint is just a compilation of all the evidence that they had before them, some of the evidence they had before them. And so if you...
Is there anything you're about to show me the defense has not seen?
No.
Very well. You may proceed.
And just for the record, and I'm sure clear that we have a Zoom link in, and on the Zoom is Mr. Robert Johnston. Mr. Robert Johnston is the brother of our victim, Leroy Johnston, as well as Ms. Spencer, who is a victim advocate in our office. They are on a Zoom feed right now on the big monitor pad here in their
Off the record, please. Mr. Johnson, can you hear me all right? The motto of the Zoom age. You are muted, sir. Would you please unmute yourself?
I think you're muted, or should I mute from here? Okay, we're on mute here. All right, go ahead, Your Honor. I think it's unmuted now.
Mr. Johnston, can you hear me all right?
Yes, I can.
Have you been able to hear everything said so far from both the state and the defense, as well as myself?
Okay, I didn't understand that last question, that last
Have you
statement.
been able to hear everything? Have you been able to hear everything said so far from the state and the defense and myself?
Okay,
Have you been able to hear everything so far said by lawyers on both sides and myself?
yes.
Thank you. And did you say that's Ms. Spencer on the other
Ms. Spencer's a victim advocate.
connection? Ms. Spencer, have you been able to hear everything so far?
Yes.
Thank you. If at any time you can't understand what's being said, please speak up. We'll be glad to repeat ourselves, all right?
Thank you.
Thank you. Back on the record, please. Would the two individuals attending via Zoom please identify themselves for the record? Mr. Johnston.
Robert Johnston.
And what relation are you, sir, to the victim, Leroy?
I'm his brother, his younger brother.
Thank you, sir.
How old are you?
I'm 75.
And where are you located right now, just the state?
Antioch, California.
Do you say your age is 75, sir?
Yes.
You are a very young sounding 75.
I just had a birthday, 6, so 75.
Thank you, sir. Ms. Spencer, would you please identify yourself for the record?
Chris Spencer, advocate with the Cuyahoga County Prosecutor's Office.
Thank you. Is somebody present with you?
No.
Thank you. Please go on, Mr. Arladell.
Thank you, Your Honor. Your Honor, what I'm showing here is, sentencing exhibit 1. So, you know, this event, the indictment indicates that this murder happened, this aggravated murder happened on September 24th, 2023. The parties to this are Mr. Viktor Vendler, known at the time to Mr. Johnston, our friend and co-worker at FedEx, as Victoria Vendler. A few days prior to September 24th, Mr. Vendler legally changed his name from Victoria to Victor, and so therefore I will endeavor to try to use the male pronouns here. So Mr. Viktor Marie Vendler and Mr. Leroy Manuel met at FedEx Richfield, where they were in the Smalls department, and they handled packages and worked often the same shift. You'll also see that another party that you will, as part of this drama, is one Evan Bernardo, who also at some point then becomes an employee at FedEx, and then is involved in a relationship with Mr. Vendler at the time, back in 2023, January 2023. So Mr. Johnston and Mr. Vendler meet and are associated together September, October of 2022. They start a relationship where Mr. Johnston takes Mr. Vendler out to lunch, buys him gifts, buys groceries, and there is at some point a relationship that happens, a sexual relationship that happens between Mr. Johnston and Mr. Vendler. Mr. Johnston at the time was 74 years old. Mr. Vendler at the time, I believe, was around 22 years old. And so that was a relationship, that was a consensual relationship. I'm going to zoom into the 24th of September 2023, and we'll get back to some other dates. So September 24th, 2023, which is the date of the event here, that we're here on, the exact date, which is the aggravated murder and tampering with evidence. We're going to see that we have text messages and Apple iCloud information from various sources that the Metroparks Police Department, Detective Bureau put together to identify a potential suspect in the murder of Mr. Johnston. You'll see here a timeline, and this is just an abbreviated timeline searches that are happening. And when we get to September 24th, 2023, we see that Mr. Vendler reaches out to Mr. Johnston at 2:43 a.m. To ask him how he's doing, and then there's a conversation that happens. Hi, I'm okay, how are you? Mr. Johnston replies, and Mr. Johnston's always texting in capital letters. At this point, there has been a chill to the relationship. There's been 37 days where Mr. Vendler has blocked Mr. Johnston. There's been allegations that Mr. Johnston took liberties with Mr. Vendler, and therefore Mr. Vendler was upset with Mr. Johnston and sought to block him via social media and whatnot. But in the month of September, Mr. Vendler reestablishes contact, unblocks Mr. Johnston, and there's a conversation that happens on September 24th, and also previous dates of September. So September 24th continues with, how was your rest? So these are just pretty good. He responds, and so again, this is just to show that there's these text messages. There's a picture of her breakfast that she posts. He tells her, I did get some rest also. And then we go through this conversation. We'll take it to the point then where there is more conversation between the two of them as we go through the night of the 24th. So that's a Sunday. So the very early morning hours of September 24th, 4:32 p.m., Mr. Vendler texts Mr. Johnston, are you sleeping? He says, no, I'm up. I just sent a proposal to China. How are you doing today, baby? He says, Ace is a nice dog. I really like him. Ace is Mr. Vendler's dog. And there's just more conversations about the dog and about who the dog likes more, him or her, or him. Either Mr. Vendler or Mr. Johnston. There's more conversation regarding that. Joke here about China. And then as we get through the early morning or late morning hours here, we're at 5 o'clock. There's a phone call at 5 o'clock of 6 minutes that Mr. Vendler places to Mr. Johnston. 6-minute phone call. And then another call. Another phone call of 27 seconds at 6:34 a.m. And then another call from Mr. Vendler to Mr. Johnston at 7:31 a.m. This is very important why the calls are being made, because everything else is in text. But the calls are being made in order to hide, and I believe that Mr. Vendler does not want any record whatsoever of where they're going to go. So instead of texting the location of the meetup, there's always going to be phone calls prior to saying, hey, let's go out to a park. And so there's some text messages here. And then we have Mr. Vendler at McCreary Avenue, living with Mr. Bernardo's family, Mr. Bernardo and his mom. And next thing you know, at 7:31, her phone stays, or Mr. Vendler's phone stays at the McCreary address. And we posit that's because Mr. Vendler wants to hide his tracks, that there's no location data. The phone itself stays at the address throughout the rest of the morning. And then what happens then is we are going to see Mr. Vendler, and here we actually have a Google shot here in this exhibit 1 of Mr. Vendler's car. This is taken in August. This is just actually a Google Drive. It's just a coincidence here of capturing his white camera. And you can see in the white camera there's this distinctive hood, damage to the hood here and other things as well. But what happens is, and through the investigation of the Metroparks, is they actually locate Mr. Vendler, although Mr. Vendler wants the world to know how Mr. Vendler surveillance camera at Lawrence School here, and it shows, it captures what we believe is Mr. Vendler's car traveling to the murder site. So this is the day of the murder. This happened at 7:45 a.m. His phone shows him being at the house, but other surveillance belies that. And so then we are now heading to what we believe is the park, park being Mill Stream Run Reservation, specifically Royalview Picnic area. On the other side of town is Mr. Johnston lives on East 59th and Outhwaite in CMHA property in an apartment. And so we see on the 24th, we see Mr. Vendler moving towards the crime scene, but we also see Mr. Johnston then on his last day here, and you'll see him here in surveillance tape collected by CMHA and also Metroparks Police. Mr. Johnston leaving his apartment for the last time on September 24th, in the morning of September 24th, around 8 o'clock. And he's going to be walking down the hall, and you can see what he's wearing, which is a kind of like work clothes, a black hat, and work boots. His next video will show him in the hallway or in the lobby. He'll be walking through here. Again, these are the last images of Mr. Johnston leaving his apartment for what he believes to be a nice leisurely hike through the Metroparks with his friend, Mr. Vendler. Mr. Johnston is leaving. He's going to be coming out of here and then leaving the lot. Mr. Johnston, again, the last time he leaves his building on September 24th, he's captured in his surveillance leaving. The next video we have is of the parking lot outside, and he will then go to his red rental car, get into the rental car, and then Google Royalview Picnic area. See him walking to his car here, and he's going then to exit the parking lot. And these are screenshots of his phone and the directions that he's going to take. It takes him to Royalview Picnic area from 8:08 to 8:42. So he arrives at 8:42 a.m. at Royalview Picnic area. This is the path you have taken. Now, where is Royalview Metroparks? And just for context purposes, I placed South Park Mall here as an anchor point. So off to the left here is South Park Mall, and right across 71 is this huge expanse of Metroparks, a park that's really kind of just full of trees and untouched, basically. Only through some trails. There's a huge expanse of wilderness here. And so you'll see then that as the only way to access the picnic area is off of Valley View Parkway, and it's a mile in through that parkway. There's a mile-long driveway to the picnic area. So the selection of this scene is very, very deliberate. Everything about what happens on the 24th is set up and is very deliberate, belying this issue about dissociation and whatnot. So there's the a long driveway, and in here is the picnic area. And you then zoom into the picnic area. And once you get to the picnic area, once you have to get a mile off the Royalview Parkway, in the picnic area, you also then have to walk several miles to get to where the crime scene happened. So not only are you so far into, away from the public, now you are further walking into a very wilderness here in order to almost walking a victim to he walked him to where he was going to be killed, and eventually where the hope was his body was going to rot. This is the picture of the entrance to that trailway. Here are some trails. You have the red trail, the yellow trail. So these are established trails. You have something called the Sugar Bush Trail. But the evidence is going to be that it wasn't going to be any of these established trails. It was going to be an off-trail hike that Mr. Vendler was going to invite Mr. Johnston to, who the evidence would have shown is more likely to be in a casino at night than out in the wilderness. He's not a wilderness person, but he loves and loved Mr. These hikes. It was a moment for him, an opportunity for him to spend time with the person that he cared about. And that happens on the 24th. We'll get into what happens on the 24th. But before that, we have to then take you back, because this is not the first time they went to this spot. The evidence would have shown that on the 10th and on the 17th, the 2 previous Sundays in a row, that Mr. Vendler invited Mr. Johnston on a hike, and they were going to hike in almost the exact same spot. This is just a conversation that goes through on the 9th through the 10th, and on the 9th at night, at 8 o'clock at night, Mr. Vendler asked, "Are you going to be up at 8 o'clock?" And he says yes, and then she calls Mr. Johnston on 9:16 a.m. on the 10th. And Mr. Vendler calls Mr. Johnston, and sees Mr. Johnston then. And we see him Googling Royalview hiking trails. Again, devoid of any text messages, leaving behind any clues. We get this from Mr. Johnston and his phone dump, is that where he's going to go. So he Googles Royalview trails, and Mr. Johnston, prior to Mr. Vendler, and he texts Mr. Vendler, "I'm here." And then he also leaves a voicemail. It's Leroy, I'm at the hiking trails here by, on Mr. Vendler's phone that was downloaded later on, indicating why he's going to go there. There's another 1 minute and 39 minute phone call on 9:25, and then at 9:48 there's a 38-second phone call. All along, Mr. Vendler's phone, by all accounts, Mr. Vendler always carries his phone for the most part, is always left at the house. He never shows up at the park. Again, trying to secrete the movements, Mr. Vendler's movements here. But Mr. Johnston, though, says, "Thank you for including me in your day. Appreciate it very much. All right, I love you now. Talk to you later. Say goodbye. Bye." And this is a voicemail.
Thank you for including me in your day. Appreciate it very much. All right? And I love you. I'll talk to you later.
And that is in the afternoon, indicating they've gone on this hike, and now he's thanking her for including him, thanking Mr. Vendler for including him today. Where are they going? Again, all this information is gleaned from Mr. Johnston's phone, and we see that this is the picnic here. Location data is, and these three different colors. The first color The yellow, which is green, the yellow color is on the 17th, and the red color is on the day that he's murdered, on the 24th. And so you'll see on the green, not only does he park at the parking spot, the picnic area, but he is then led all the way to eventually where his body would be found 2 weeks later. So coincidentally, and it's not a coincidence at all, that all 3 times they're within feet of where his body would be found. And this is not on a trail. This is way off the trail. Something that is not going to, nobody's going to actually run into the body. And again, the hope was that the body would decompose and it would disintegrate. Again, on the 12th, which is a few days later, he texts, "I liked our little hike. We have to take another. That was nice and relaxing. Thank you. Take care, baby." Anything on her phone is completely wiped out away. With regard, Mr. Vendler's phone is completely wiped as to any the goings about on the 10th. But Mr. Johnston is appreciated again, Mr. Vendler, spending time with him and taking him on a hike, and he calls it nice and relaxing. You would have heard later in the trial a 20-minute long hike through very, very rough terrain by police officers, by EMS, by fire to try to retrieve the body, and they would not call it a nice and relaxing walk. It's a very, very treacherous walk through again, not a trail, but a kind of bootleg kind of trail at the Metroparks down there. That was on the 10th. The 17th rolls around, that's next Sunday. There's a conversation had the day before, or that morning, very early in the morning, what are you doing, how are you doing, Mr. Johnson, how was your day, are you feeling better, to Mr. Vendler. Mr. Vendler says, I'm going to have tea. And then Mr. Vendler says, how about that place? We went last time. Again, very, very, not naming the place, but how about that place? And then Mr. Johnson says, baby, what place is that? We went to a lot of places, baby. You have to refresh my memory. Now, easy enough to just type in Royalview, but no, there's a 6-minute long call at 5:22 a.m. from Mr. Vendler to Mr. Johnson, 6:05-minute long call. And then at 6:33 a.m., there's another minute and 30 call from Mr. Vendler to Mr. Johnson. And after that call, at 6:33, he Googles 6:35 Royalview Picnic Area. So he's Googling again. This is the second time he's going to be traveling there. He's going to Google that, and he then texts her at 7:19, I am on I-71 now. He texts Mr. Vendler, I am on I-71 now. And that's the 17th. And again, he parks in about the same spot in the picnic area, and they walk the same hike, and his Google location places him within feet of where he will end up the following week dead. Again, it's a very treacherous walk along the river. There's a distance between that and an actual established trail. And then at 9:17 at 10:56, he home hike is over and they're done. And now we get to the 24th. We had seen early on the 24th and the motion from the Lawrence School going to the 24th and him leaving his seat. We're back on the 24th, the day of this homicide. And again, we're going to be parking in about the same spot Mr. Johnson is, and he's going to end up being walked to around the same spot that he walked to on the 10th of September, 2023, and on the 17th of September, 2023. Now, whereas on the 10th, on the 17th, Mr. Johnston walked out, he will not be walking. As Mr. Vendler has led him, that will show to the spot, to the kill spot, to where his body was going to rot away, and again, hide the evidence of the murder. These are the locations from his GPS data location. And this is just an illustration of how far he's off the trail, how far and deep into this ravine that they went off established trails in order then for Mr. Vendler to secrete his crime. And then we have then the body being found on September 30th. And how it's found is that somebody's actually hunting for mushrooms and edible mushrooms, foraged, and their dog is off leash, and their dog finds the body, and they come upon the body, call 911, and the investigation starts with Mr. Johnston. They discover Mr. Johnston has a bullet hole to the back of the head, and no other injuries, and he's then recovered from this spot where we just talked about. There's just another, I blacked out his face here, but this is Mr. Johnston. We saw him leaving CMHA. This is how he's dressed. His hat is between the crook of his arm, and he's now left this world. We have no indication, again, the phone, Mr. Vendler's phone is at his house, again, showing prior calculation design, showing an understanding and ability to carry out very, very thoughtful plan here. But because of the work of the Metroparks Police Department, especially Lieutenant Silvis, in finding a stack, we're actually able to find a video on the way back from a gas station or a service station, a motion activated video, even at that, of Mr. Vendler in his car after the murder. And you'll see it coming up here. It'll just appear because it's motion activated. And that's Mr. Vendler after the murder, to the query address. And Mr. Vendler will come back here on Broadview and take off and go towards this white vehicle right here, go towards Mr. Bernardo's home. Again, the finding this video was miraculous in itself, because not only do you have to watch all this video, but again, it's a motion activated system. And so we compare then Mr. Vendler's car, and there's nobody in the passenger seat, it's only Mr. Vendler in the driver's seat, to the known photos of her car, and they match up, the damage matches up, and several other details here match up to her vehicle, to his vehicle. And here then, so that's at 9:48 a.m. Now I've got to get back home to get my phone, and once I get back home to get my phone, I now have to start my alibi. And now I'm going to text, for the very first time, I'm going to text Mr. Johnston, I'm so sorry, at 9:56. I can't meet you. My dog started to vomit, and therefore establishing what Mr. Vendler was going to be the alibi. I don't know what he got into. And then we see more action and more kind of things that they did. Now this is after the murder, after shooting Mr. Johnston in the back of the head. There's videos here playing, and there's this tattoo, or this picture of a tattoo, what would become a tattoo. Evidence will show that Mr. Vendler has a fascination with the story of Medusa. Medusa is mythology, in the Odyssey or the Iliad, the story of Medusa being raped by Poseidon, Medusa being a maiden of Athena, and she gets raped by Poseidon. To get back at Athena, instead of punishing Poseidon, decides to punish Medusa, turning her into a gargoyle type figure with hair of snakes and the ability, if any male sees her, to turn that male into stone. And it's this kind of, so this it's an issue of then being banished to an island, and also only after Perseus then goes to the island and cuts off Medusa's head does he end Medusa's reign of terror, of causing men to turn to stone. And so then you'll have a famous picture of Poseidon holding up Medusa's head. Here you have Medusa holding up, or Perseus holding up Medusa's head. Here you have a picture of Medusa holding up her rapist's head, and that is Poseidon. And this is the motive behind this whole tale, is that Mr. Vendler believed that Mr. Johnston took advantage of her while she was asleep, that there were some text messages early on with regards to his wake-up sex, and she had a fascination with Mr. Johnston having raped her, and so this is the tattoo she's going to get, and she does get on the 30th to commemorate her slaying her, what she believes is her rapist, and she actually has that on her arm. But this is kind of the picture she gets that day that she's now completed her mission to slay Mr. Johnston. There's more things about TikToks and videos, and especially about there's some witchcraft and seance things here, an altar, and there's conversations between her and Mr. Bernardo, and we'll get to Mr. Bernardo later when we get to Mr. Bernardo. But it's our understanding that after she comes back, that the 9mm weapon she uses is taken apart and disposed of by Mr. Bernardo in pieces at some point.
Are the references to laundry code or something, or should they be taken at face value in state's theory?
Yeah, it's not completely clear. We do know that she jumped into the shower to try to get off any of the gunpowder or the smoke. He tells us later, and in fact, it's in the shower where Mr. Bernardo, who's unfamiliar with the 9mm, hands the gun to Mr. Vendler. Mr. Vendler is able to disassemble it and then give it back to Mr. Bernardo, who then disposes of it piece by piece. So then we go on, and then we talk about lamb, and there's a lot of detail in here, but there's talk about cooking lamb, and he's proud of her for cooking lamb, Mr. Bernardo is. But at the very end of this, she sends a text message to Mr. Johnston. Says, and they always talk about food. Food was one of their subjects. And there's one final text message to Mr. Johnston on this day: made lamb. Now, she knows full well that she's put a bullet in the back of his head earlier in the day. At 4:36, and she's making lamb and texting Mr. Johnston. On the 30th, when she does a tattoo, she will a picture of the tattoo. Now, piecing this all together with the phone information, with a lot of corroborating evidence, Mr. Vendler was arrested, and Mr. Vendler then sat down with an interview with Lieutenant Silvis. I'm going to play for you just a clip of, this is a 6-hour interview, and this is a clip that kind of takes us through what happened down at that spot that I showed earlier, what happened and how it happened.
So when you went down there with them the third time, it was nice to you, but you decided
I knew I had to go do with it.
Right. So you said I was surprised. You stood up and said, did you say like, wait, hold on?
Yeah.
Don't look.
I just wanted to put this eyeballs.
Okay.
This one I was finished up a little bit.
Well, they're probably mostly looking at a shot. Yeah.
Mines.
Very
It
good.
was
So you got, okay, so you're sitting next to them, you guys are just talking normal. Then you say, I had to get up, I was surprised. Like, what did you remember exactly?
Yeah, that's literally what I said.
You said, what'd you say?
I was like, I was surprised to you that I got like, oh, this is that. Yeah, and then I stood up and I got mine.
And you said, close your eyes. And then it was just quick, you just took it out of the backpack. And then how far away were you? I mean, we know you were close.
Pretty close. Because I didn't want to miss, because
Yeah.
if I had to,
Yeah. Like how close do you think you feel like it is?
I don't know, maybe.
Foot from there. Yeah.
That was just a clip from that 6-hour interview, and that basically, just for the record here, the clip, she explains that as there's the third time, as they were sitting down next to each other, she gets up, tells him, I have a surprise for you, and basically shoots him from a few feet away on the back of the head. And the final slide here is the autopsy that shows injuries in the back of the head. Mr. Johnston, sorry. So this is State's Exhibit Sentencing 1. I will give a USB with State's Exhibit 2, which is a transcript of the entire 6-hour interview. State's Exhibit 2, which is the actual State's Exhibit 3, which is the video, the audio interview of this, because the video is too large to put on this USB. And State's Exhibit 4, sentencing State's Exhibit 4, which is the autopsy report. I just wanted to kind of establish for the record the basis for the plea to aggravated murder, prior copy design, and for the use of corpse. There's a basis for that factual basis. And I could, if defense or wants, I can have Lieutenant Silvis and or Dr. Winslow take the stand and explain this and be under oath to establish this, unless they take us through these fact patterns. But I thought to do it like this would suffice unless there's a.
Mr. Johnston, would you like the lieutenant to take the stand?
Judge, I don't think that's necessary.
Mr. Sponsor?
No, Your Honor.
Very well.
So, with that being said, and with those state's exhibits being entered, as well as the exhibits of the court psychiatric clinic, I think those are part of the record to begin with, the court's record, but.
Does the defense have any objection to any exhibits the state is now offering in sentencing?
No, Your Honor.
So with that being said, Your Honor, and because Mr. Vendler was forthcoming, the cooperation, and the job that Mr. Chauncey and Mr. Sponsor have done, there is a range of aggravated murder. Mr. Vendler entered a plea of aggravated murder, and the agreement was that there would be served the low end of that aggravated murder with a 1-year spec for the gun that was used. So it would be, there's an agreed life in prison with the possibility of parole eligibility only after serving the full 21 years in prison. Ask Mr. Johnson have anything to say, or is that the next?
Yes, if you would please enlarge the meeting window. Mr. Johnston, would you unmute yourself, please?
All right.
Do you have a camera that you can activate?
Well, what is that for?
I would like to see you if possible. If you would prefer not to be seen, then I will not force you.
Your Honor, just so you know, Mr. Johnson, there is media in the courtroom. There may be, I don't know.
That is true.
Your Honor.
Are you concerned, sir, about your
Wait a
relation?
minute, wait a minute. You just said there's, all I heard you say, just so you know, isn't it?
Yes, sir. There are cameras from two TV stations here. If you would prefer not to be seen, I will direct them to turn their cameras away. Are you concerned about
man.
having? Are you concerned about having your face appear on TV?
No, it's all right, yeah.
If so, then I'll ask you to please activate your camera.
You got me?
I just see your name still.
Wait a minute, hold on.
I think something's coming through. No.
There you are. Yes. Thank you. What would you like to tell me, sir?
Well, I mean, you know, it's a lot of evidence. Don't really have anything to say. I mean, you put together a good case. I'm glad you got the evidence. So,
Tell me something about your brother, please.
well, you know, we didn't really have a big relationship because we got apart over the years, so, you know.
Did you have an argument or did you drift apart?
Did we have what?
Did you have an argument or did you simply drift apart over time?
No, we just had two different paths, that's all. I mean, you know, he was a different type of person and I didn't want to deal with that, that's all.
Anything else you wish to tell me, sir?
No, that's it.
Thank you. Would the defense like to inquire?
No, Your Honor.
Thank you. Would the advocate like to be heard? Anything further from the state?
Your Honor, I asked Lieutenant Silva if the Metroparks would like to be heard, but he declined.
You may make a statement. It need not be under oath in light of the defense's statement.
We concur with the proposed plea agreement, and we think it adequately brings justice to the Johnston family.
Thank you. Would you spell your last name for me, please, Lieutenant?
It's spelled Sylvis.
Thank you. Anything further from the state?
No, Your Honor, again, it was something that we were approached with, we agreed to it, the letters, and I just asked the court to, again, go through, address Mr. Vendler personally, just to make sure that we're all on the same page and the record is clear, that this is something that Mr. Vendler wants to do, enter the plea and be sentenced on what they agreed to be sentenced on.
Thank you. For the defense, Mr. Johnston.
Thank you, Your Honor. On behalf of Mr. Vendler, acceptability here by pleading guilty to the aggravated murder charge. Judge, I'll be pretty brief here today as we do have a joint agreed recommended sentence. Your Honor, I know you're well aware of the facts and circumstances as just presented, as well as some of the mental health history through the court psychiatric clinic report. Viktor's prior record prior to this has been in the county jail for over a year now. Judge, we would just ask that with all of the information that was presented today, we are still in agreement with that minimum sentence on the plea of life with the possibility of parole after 21 years. We would ask the court to impose that.
Credit tally today.
I have from May 28th of last year to today, Your Honor. $398 days is what I get, Judge.
That is also my count. Does the state have any information to the contrary?
No, Your Honor, I believe that the arrest was made at the end of May 2024, exact date, but you say May 28th?
So.
Yeah, that sounds correct.
Thank you. Mr. Sponsor, anything you wish to add?
Your Honor, we just asked the court to follow the agreed recommended sentence at this time, and I won't bother to echo any of Mr. Shawsey's comments. Thank you.
Mr. Vendler, would you like to be heard?
No, thank you, Your Honor.
Were you appointed or retained, gentlemen? A moment, please. Is the state's theory, to be clear, that the gross abuse of a corpse charge was grounded upon the victim's body simply being abandoned in the woods with the expectation it would not be found?
Yes, Your Honor, that left to animals and whatnot to either, abuse it or for it to just be disintegrated.
I understand. And no report being made to police, and no report having been made to police?
No report, yes.
Thank you. I assume in light of the defendant's current gender identity, he would be conveyed to the Lorraine Correctional Institution. Is that so?
Your Honor, I am not sure about how they will handle that.
Is the defense seeking that he be referred to the Ohio Reformatory for Women? Would you like to have a word with your client?
Yes, please, Judge.
Please do.
The Ohio Reformatory for Women, Your Honor.
Would the state like to hear on that one?
No, Your Honor, we'll defer.
I'll make such a referral. I will caution the defendant that the Ohio Department of Rehabilitation and Corrections, which runs Ohio's prisons, will make its own determination. And my decision on that point, as to which institution you go, is not controlling upon them. You understand?
Yes, Your Honor.
I will note that it is at defense request.
Thank you, Judge.
Certainly, without objection.
One other thing, Your Honor, just so that, if you want to enter into evidence the first 5 jail calls after the plea that happened last week.
Do you wish to do so this time?
Yes,
You may.
I'll put them on a USB just for the record.
You do not wish to play them to your own.
I don't think it's necessary. I just think it's part. I'll summarize that again. It's first couple calls. Mr. Vendler is happy with the plea, and then there's this change after discussing it with a family member, and then all of a sudden there's excuses about why it should be changed. So, and then it goes back to no, I want to go. So there's been back and forth with regards to that. I just want to make sure that the record's clear that because it's still just because it was said in writing that wasn't comprehended. I believe it was comprehended, and I asked the court to ask again whether it was comprehended or not at the time, and just, you know, there's already, so I want to include that so any reviewing court can see those
Thank you.
calls.
Mr. Shaughnessy, will you agree with Mr. Alabella's brief characterization of those State of the House calls?
Mr. Shaughnessy or Mr. Smatser, I
You have
can't.
not.
I have not. They just are something that.
That is why I specifically asked you earlier, if there was anything you wish to introduce to me in this hearing, has the defense seen or heard it?
Oh.
And I understood you to say the defense had.
With regards to the evidence in the case, this is with regards to the plea that's just happening, or after the plea. And I did not play anything here that they had not heard.
That if you wish to introduce it into evidence, the defense ought to be aware of it. The defense ought to have a chance to review it. Mr. Shaughnessy, would you like to be heard on this point?
Can I have 1 second, Judge?
You may.
Judge, I think we're still in the same position as I said earlier, that we do not have a pending motion to withdraw any plea in this case. However, if there is going to be something submitted to the court, I would ask for the opportunity to review it before.
I will refuse the state the opportunity to introduce these jailhouse calls into evidence at this hearing. I will direct the state to preserve it inviolate in case it is later needed in any subsequent appellate proceedings. It will, however, play no role in my decision on sentencing, and the record I have not heard these calls myself, as it appears the defense has not heard them either. Is that acceptable to the state?
I could play them for you right now if the court wishes.
Again, I believe it may be prejudicial to the defendant, as his attorneys have not had a chance to review it before this moment. Very well. You may be seated. Any further from the defense?
No, Your Honor, thank you.
Mr. Swanson?
No, Your Honor, thank you.
Mr. Vendler, anything else you wish to say?
No, Your Honor.
I will ask you directly. Do you wish to stand by the plea that you had earlier entered before this court?
Yes, Your Honor.
Do you understand in doing so that you would be subject to an agreed life sentence with the possibility of parole only after 20
Yes, Your Honor.
for the sentencing at this time?
Can you repeat that?
Do you wish that I go forward with sentencing at this time?
Yes, Your Honor.
Have you had enough time to fully discuss this case and all its issues with attorneys before now?
Yes, Your Honor.
Any questions you have for me?
No, Your Honor.
Very well. Thank you. Is the state now satisfied with my inquiry of the defendant?
Thank you, Your Honor.
Thank you. love you, and who you once apparently loved, and especially under these circumstances, is a particularly heinous and shocking crime. I'm deeply disturbed by what I've learned about this case, and the life ended unnecessarily, cruelly. Before imposing sentence, the court notes for the record that it's considered the record itself, the relevant, material, and competent statements made here. All documents submitted to the court over the course of these proceedings up to today, the defendant's prior record, and the nature of the offenses. The court must and has formulated its decision based upon the overriding principles and purposes of felony sentencing, namely, to protect the public from future criminal acts by the defendant or others, and to punish the defendant using the minimum sanctions that the court determines accomplish those purposes, without imposing an unnecessary burden on the state or local government resources under Revised Code 29.11a. To achieve these purposes, the court has considered the need for incapacitation, deterrence, and rehabilitation. The court must and has also considered the seriousness and recidivism factors relevant to the offense and the offender pursuant to Revised Code 29.12. As to seriousness, these factors are not at all helpful. As to recidivism, they are, on balance, helpful to the defendant. The court must and has determined that the sentence being imposed does not demean the seriousness of the offenses and the impact it had on the late victim and next of kin, and is consistent with other similar offenses committed by comparable offenders. Finally, of course, the sentence is not based upon any impermissible or irrelevant factors, including but not limited to the race, sex, age, national or ethnic origin, sexual orientation, gender identity, or religion of the defendant. Do you understand all this, Mr. Vendler?
Yes, Your Honor.
I commend the lawyers for both the state and the defense for their commitment to seeing that justice is done, for the representation of their respective clients, the state of Ohio and Mr. Vendler. Agreed life sentence appropriate and necessary in this case, and that anything else, especially anything less, would be to demean the seriousness of the offense. Accordingly, that is the sentence I will impose as to count 1, aggravated. As to count 5, gross abuse of a corpse, a felony of 5th degree, I will impose a 12-month prison term, to be served concurrently with the underlying life sentence. I will impose fines. I will give the defendant jail credit for 398 days already served. Do you understand, sir?
Yes, Your Honor.
I will note that you have withdrawn your 2 handwritten letters to the court seeking to withdraw your plea. I will accept your clear and unequivocal representations to me today on the record that you wish to withdraw those letters, to stand by your earlier plea, and to go forward with sentencing. I am persuaded that at all times that you've appeared before me in open court, that you have been of sound mind, fully oriented, fully understanding everything that's going on, and that both at the time of the plea and now at the time of the sentence, that is still true. As you are indigent and qualified for the appointment of counsel, anything further from the state?
You
may. Mr. Alabama, I understand there's another matter you wish to place on record.
Just for clarification purposes, with regards to count 5, which is gross use of the corpse. I know we're fully advised of a discretionary post-release control period, I think up to 2 years. But I just want to make sure that that's part of the record, part of the sentence on count 5.
My recollection is, in our earlier discussion, there's consensus between the court and counsel that post-release control will not apply, but rather that the defendant would be subject to parole supervision upon his eventual release. Is that your understanding, Mr. Johnston?
Yes, Your Honor.
Mr. Slaughter? Yes, Your Honor. Do you think it's necessary under the circumstances that the court make a determination as to post-release control on count 5, Mr. Johnston?
Your Honor, I don't believe so. I think that Mr. Vendler understands the parole supervision that is that comes with this sentence.
Mr. Slaughter, would you concur?
I would agree with Mr. Chauncey.
Thank you. Anything further from the state?
No, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Thank you very much.
Any questions you have for me, Mr. Vendler?
No, Your Honor.
Thank you. You have a long time to consider what you've done. Think carefully about it. Resolve never to do anything of this sort again. Certainly not while in the institution, to hurt anyone in any way, to obey the law and to choose a better path forward. You're still a young person and have your life ahead of you. Resolve to put this mistake behind you and never do anything of the kind again. Do you understand?
Yes, Your Honor.
We are adjourned. Share the transport. Thank you all.
Thank you, Judge.
Mr. Johnson, thank you for your attendance via Zoom. You are free to break the Zoom connection. Likewise, Ms. Spencer.
Mr.
Okay, thank you.
Mr. Johnson, a moment here.
One other thing, Mr. Johnston.
Just because I believe there was a co-defendant taking a plea today, and the victim's family has a right to.
Did you wish Mr. Johnston to remain on the line?
I want to ask him if he wants to attend that, because he has a right to attend.
Let's go off the record, please. Mr. Johnson, you do have the right to attend the hearing, which will be beginning shortly, as to the co-defendant. Mr. Bernard,
I'll stay there. I'll stay for that.
if you wish to stay on the line, you may do so.
Yes.
Thank you.
Yes, I do.
Ms. Spencer.